that I saw set an exam date of today's date, and afterwards, Mr. Frezza, who was present, Mr. Patterson wasn't there on that day, asked if we could come down here to see if Your Honor could be fair to Mr. Banks in light of the contact or the alleged contact that I was advised about at 36th District Court. Your Honor was kind enough to speak with us at the bench. Your Honor did indicate that, did recall the legislative update session, and at that point, during the conversation, Your Honor referred to either Mr. Banks or Mr. Banks' behavior at that session as a prick.
I'm sorry,
Prick, P-R-I-C-K, on at least 3 different occasions. Your Honor was also upset that the exam got put into August and said I was a prick for appealing, or I was the prick that appealed. During that conversation at the bench, the court clerk also interjected on at least 2 occasions that he had called Judge Hathaway's and told them that the exam couldn't be passed July 30th. I thought long and hard about this for the past couple weeks, and based on all that, I believe that the appropriate remedy is to have Your Honor disqualified. I think that based on the comments, based on the interaction with the court staff contacting Judge Hathaway, there's both a bias and a prejudice against Mr. Banks. And I also think because of the contact between this court and Judge Hathaway's, the appearance of impropriety should be avoided, and the case should be reassigned to another judge. Thank you.
Well, I don't think this prosecutor has much to say about that, or unless you'd like to respond.
Judge, obviously I can't factually comment to whatever conversation Mr. Gunning was talking about. I would reference the court to Mission Code Rule 2.003, which goes towards the disqualification of the judge. And in that particular rule, it states that the time for filing in the trial court, which this is, it states that to avoid delaying trial and inconveniencing the witnesses, all motions for disqualification must be filed within 14 days of the discovery of the grounds for disqualification. Mr. Gunning, his client, and Mr. Frezza were before Judge Hathaway, I believe it was on July 13th, which was the day before this exam was supposed to occur. Well more than 2 weeks has passed. Therefore, Mr. Gunning, in his motion, is not compliant with the rule itself. It says he was supposed to have filed it more than 3 weeks ago. And he did not. He filed it yesterday. I think the case law also states that the court can take that into factor in factoring its decision on whether to deny the motion. Other than that, the only thing I would add is that the motion has to state that there is an actual bias or actual prejudice. And I would ask the court to deny the motion unless the court perceives there to be some type of prejudice or bias.
Got it?
In response, Your Honor, I did think long and hard about this motion. Last week, I did submit a travel order to the court through a colleague of mine. Although I didn't hear it from him, I heard that there were some comments made about the appeal that I filed by a spectator in the courtroom, by Your Honor, and that just kind of solidified the basis for this motion. That's all I have to say.
Okay. Well, first of all, let's set some facts straight. I recall Mr. Banks coming to speak to the 36th District Court at our judges meeting. He and I had a disagreement over some issue at the very beginning of the meeting, 1 or 2 minutes. Then we went into the meeting while he was there. That happened last year sometime. Now, if he feels that because I disagreed with some position he took, that I am prejudiced against him, then he's absolutely incorrect. When I was told of his indictment, actually I was told by another judge that Brian Banks got indicted. I said, who is Brian Banks? So I don't know Mr. Banks. He's not my representative. He is a state rep. I know that because he came to our meeting and spoke to us about the de-insurance issue that's still pending before the state legislature, number one. So in your motion, Mr. Banks told you something that's completely made up, in that after the meeting, he said some words to me about leave me alone, or he didn't like my demeanor, And that is 1,000% false. After the meeting, Mr. Banks had conversations with some of the other judges. I went on about my business and did my docket. Why would I stop and talk to him? I didn't have anything against him. We disagreed. He did his presentation. I was done with it. Secondly, I never called you nor Mr. Banks a prick, ever. So you made that up.
That is wrong.
Excuse me.
I'm sorry.
Excuse me.
I'm sorry.
Thirdly, on this record, you told this court that your vacation, or your prepaid vacation, was July 20th through the 30th. This was July the 8th when you made this statement. And I said, well, Mr. Gonick, his preliminary exam is set for the 14th. What's the problem? That's 6 days before you go on vacation. So then you acquiesced, you agreed to the 14th, and then you went to Judge Hathaway to get that changed after I said, this is plenty of time. You didn't tell me you had 2,000 or more pages of discovery at that time. You just said you had the disc for discovery. You thought there were a couple hundred pages of discovery. I said, what's the problem with you getting this done 6 days before you go on vacation? And when you left out of this courtroom, the date was set for the 14th of July. July 13th, you and the Attorney General, Assistant Attorney General, came here. We had some discussions at the bench here. You indicated that Judge Hathaway had changed my docket date. No, I did not appreciate that because I don't believe he has any authority to run my docket. So, you went to Judge Hathaway. I have a copy of the hearing, the transcription of the hearing. You were not forthcoming with Judge Hathaway. I did call Judge Hathaway, and he and I had some discussions. And if you think I had some words to say about your client, then you should have heard what he said about it. So, I don't have any prejudice against Mr. Banks. These charges stem from some things that happened 6 years ago. It's incumbent upon the Attorney General's office to prove them, and that's what they got to do today. So, I don't like being lied upon to another judge, no. But you did that. I didn't like it at all when I read your motion yesterday. I thought that it was not timely filed, and it hasn't been. You just gave this to me yesterday. So, there's a number of reasons I'm going to deny your motion. Number one, it wasn't timely filed. Number two, it contains many, many falsehoods. And number three, I don't care anything about Mr. Banks. He's just another defendant. When I get through with him, I'll do another case. Okay? So your motion for me to recuse myself is denied. Mr. Banks, please have a seat.
I'd like to go before the Chief Judge pursuant to the court
Well,
rule.
the Chief Judge of the 36th District Court does not function as an appellate court where she can review my decisions de novo. No.
That's absolutely incorrect.
Well,
MCR
No, it is not.
2.003
She does not.
D3.
She does not have the authority to review my decision. She is not the appellate judge of the 36th District
The court rules provide specifically that if it's denied by a court, it goes to the Chief Judge of that court.
This is the problem. You didn't file your motion when you should have. You had 3 weeks to get it to me. You got it to me yesterday after court was over. You didn't file your motion timely, and I am denying every allegation in your motion.
Well,
Okay,
I
Mr.
deny.
Gonick?
What you state is untrue
Mr.
because
Gonick?
you used the word
Mr.
prick,
Gonick, I
and the
did
record
not.
will reflect at
Mr.
least
Gonick?
5 times at the
Mr.
bench.
Gonick, now it's 5 times. Yesterday you said in your motion.
I said
it
at
was
least.
3. Mr. Gonick, we're going to proceed to preliminary.
I'm not proceeding to an exam, Your Honor.
Then what do you want to do, Mr. Gonick?
I want to appeal to the Chief
Well,
Judge.
you
of the
get to
court.
appeal after you do this exam. That's what we're here for today.
No, that's not what the court rules say.
Please do your job.
I'm asking you to do your
Mr.
job and
Gonick.
follow the court rules, Your Honor.
Mr. Gonick, you should have followed the court rules 3 weeks ago.
Well,
Mr. Gonick, please call. Please have a seat. I'm going to have the Attorney General call his witness. There is a mutual sequestration order in effect.
Your Honor, I'm not
Excuse me.
participating in this
Please,
exam.
Please don't interrupt. There's a mutual sequestration order in effect. Mr. Gonick, you come here this morning, I made my ruling, you gotta live with it, okay? With an exception for the officer in charge of the case.
Yes, Your Honor.
All right?
Your Honor, the first witness is in the hallway. The first witness that is coming in just asked me to ask the court if it is possible for the media not to show her face and or report out her name.
All right, not a problem, is that? Okay,
Thank you.
all right. Excuse me, how many witnesses will be calling this morning?
Judge, I have 2, maybe 3 at the most. I'm believing 2.
All right.
Your Honor, I would just request a stay or a brief recess.
Motion denied, sir. Wait, you already asked for that.
I'm just asking you to comply with the court rules.
And I'm asking you to comply with the court rules, Mr. Gonick, and proceed to preliminary exam in this matter. You could have done this 3 weeks ago, sir, without delay. And I know why it was delayed. Mr. Banks was in the middle of primary. He was being challenged. And I don't blame him. I would have asked for an adjournment too, but you should have been forthcoming. Instead of saying it was because you had vacation, I would have granted your motion had you told me you had 2,000 pages, but that's not what you said.
I didn't
You
learn
said-
of it till that after that first hearing.
Well, then you could have come back to me and said, Judge, can we get a new date because I just found out we got.
Well, that still
I got
doesn't
10
excuse
times.
your comments
We
at the
got
bench.
We've got 10 times as many pages as I thought, and my client is in the middle of a political race. My client is in the middle of a political race. I have to run for re-election. I understand that type of. I mean, that's a legitimate concern. But you didn't say that. You didn't say either one. You didn't say either one.
I told you the reason, because I had a prepaid vacation. I wanted to be prepared.
That's right.
And you summarily, when I asked for an August date, you
Gonick?
just summarily, without even requesting a response.
And then we went over it, and I asked you what would you schedule, and you said it was July 20th through the 30th, and I said, well, that's 6 days after the scheduled preliminary exam. And so that's why I denied your motion. Okay. And we
Well-
set it for a date, and you went to Judge Hathaway, and he decided he was going to run my docket by putting things on my docket without consulting with me. Yes, I did tell Judge Hathaway. So now, we're here at preliminary exam, Mr. Gonick. All right? So, let's go. Who's the witness?
Well, I'm just indicating to the court,
On the record.
and on the record, I am going to file a judicial tenure complaint for your misstatements on the record about what occurred at the bench. Mr. Frezza was there. And also for not allowing me the opportunity to go before the chief judge on this motion and not giving me a brief recess so I can at least seek an appellate remedy in the circuit court of the Wayne County Circuit Court.
Okay. Noted for the record. Call your witness. All right, back on the record, while we wait for the witness, I can put some other information on the record with regard to another case. This is People versus Michael Thompson
Mr. Thompson, come on up.
on file number 16, 57409. Where's Mr. Thompson?
He's coming, Judge. Stay right here.
Good morning, sir. Your name, please?
Michael Thompson.
And on behalf of Mr. Thompson?
Good morning, Judge Leslie Cooper. On behalf of Mr. Thompson, he stands to my right.
And
We
for the
have,
people.
Good morning, Your Honor. Greg Eckert, the people.
we have discussed this morning Mr. Thompson's right to hold a preliminary examination. He understands that right and has chosen to waive his exam. He has executed the waiver form.
All right, Mr. Thompson, you understand that in giving up your rights to a preliminary exam, you are giving up the right to have the prosecutor prove to me two things. Number one, that there's probable cause to believe that possession with intent to deliver a controlled substance has occurred in the city of Detroit, and probable cause to believe that you're the person that committed that offense. Understand, Mr. Thompson, that this is not the end of the matter, that you will be bound over to the Third Circuit Criminal Division here at Frank Murphy for further disposition, plea bargaining, discussion of the charges. That's your understanding, sir.
Yes.
I'm going to sign the bind over.
People have no objections to the waiver, Your Honor.
Okay, and Mr. Thompson is enjoying $7,500 personal bond.
Yes, Judge.
Any objection to that bond continuing?
No, Judge.
All right, and his AOI date is 2 weeks from today. And that would be August 23rd at 8:30
Thank you, Judge.
a.m.
Thank you.
All right, there you go. Come back on the 23rd.
Mr. Patterson, back on your record with People versus Banks.
Good morning again, Your Honor. Rondé Patterson, representing the people.
Mr. Gonick,
I'm not participating in this exam.
you've already put your appearance on the record, so you are here. You don't have to cross-examine if you don't like. Is this your witness?
Yes, Your Honor.
All right, please give your name to the court reporter.
Just one.
Raise your right hand, ma'am. Do you swear or affirm that the testimony you're about to give is the whole truth, nothing but the truth, so help you God?
Yes.
You may be seated. There is a microphone in the chair. Grab it and make sure it's turned off. Thank you.
May I proceed, Your Honor?
Yes, you may.
Good morning, ma'am.
Good morning.
Make sure that that microphone that you have, you keep it kind of close to you. Make sure when you answer the question, you project all the way to the back of the courtroom so everyone can hear you. Can you state your name for the record, please?
Beverly Watkins Ford. I'm sorry, one more time.
Beverly Watkins Ford.
And do you go by Watkins Fuller or do you go by Fuller? What would you prefer?
Watkins, sir.
Watkins.
Yes, sir.
Miss Watkins, do you know a person named Brian Roderick Banks?
Yes.
And do you see that person here in the courtroom today?
Yes.
Can you point to that person and describe what's being worn?
On the far right, gray suit with a fuchsia tie.
And is he sitting at a table,
Sitting at the table on the far right.
wearing glasses?
Yes.
Your Honor, can the record reflect that the witnesses identify the defendant, Mr. Brian Roderick Banks?
Record will so reflect.
And ma'am, please speak a lot louder. Okay.
And don't worry about the people at the back of the court. Worry about the person up here on the bench. I need to hear you. Okay?
Yes, ma'am.
Miss Watkins, do you know personally Brian Banks?
Yes.
How long have you known Brian Banks?
More than 19 years.
And over the majority of the 19 years, would you say that you and Brian Banks were friends?
Yes.
Were you good friends?
Yes.
Let me direct your attention back to the month of June 2010. Would you talk to Brian Banks on a regular occasion?
Yes.
How often?
Nearly every day.
And when you say you would talk to him nearly every day, would you see him every day, or would this be a combination of seeing him in person and or over the phone?
Mostly over the phone.
Now, back in June of 2010, did you own or operate a business called IHI Consultants?
Yes.
And were you the owner or the person in charge of that particular business?
Yes.
Did you have any other partners?
No.
Did you have employees?
No.
What type of business is IHI Consulting?
Desktop publishing and printing, doing wedding programs, obituaries, business plans, brochures, that kind of thing.
And this particular business, prior to June 2010, how long had you been in business?
At this, I'd say more than maybe 5 years.
5 years prior to June 2010.
Yes.
Okay. IHI Consulting, did that operate out of a building that you own? Did it operate out of some building you lease, or did it operate out of your home?
No.
And I believe you've already testified. You didn't have any employees?
No.
Did you have a human resources department?
No.
Did you have the ability, or did you issue out, or did you issue or make pay stubs for people who did work for you for IHI Consulting?
No.
Did something happen in June of 2010 with Mr. Brian Banks that causes you to be here in court today?
Yes.
And can you tell the court what happened during that particular month and that year?
I was asked if I had something that could assist Brian as far as pay stubs.
Mr. Banks is asking you about something that would assist with pay stubs.
Yes.
Can you be more specific? What is he asking you?
He asked if I had a document that produced a pay stub.
And what did you tell him?
Yes.
And this document that you had regarding the pay stub, is this something you had on your computer?
Yes.
Did you have the ability to create a pay stub?
Yes.
And what type of program are you using that would allow you to create a pay stub?
Microsoft Excel.
And what exactly did Mr. Banks want you to do with that particular program that you had?
Produce the paycheck stuff and send it to him by email.
All right. Now, did you produce a pay stub check for Mr. Banks?
Your Honor, before this witness answers this question, it's clear that she's about to, if she answers an affirmative, implicate herself in criminal activity, which she may have a Fifth Amendment right not to. She should be appointed a lawyer before she gives any answers.
Judge, my response to that is, one, in this particular case, in these allegations, the statute of limitations has run. That's the first thing. The second thing is that I appreciate Mr. Gunn looking out on behalf of Ms. Watkins, and I anticipated that he may try to represent Ms. Watkins. And so therefore, if that is an issue, I've also prepared a use immunity order for Ms. Watkins to proceed. I've explained to her what the use immunity order would do. It would allow her to proceed and testify, and therefore, if the court wants to take a minute to review the petition in the order, I've explained that to Ms. Watkins at 7:30 this morning. We can then proceed. I don't know that it's necessary because the statute of limitations has run, and we cannot bring charges against her, but we can keep this case moving in that fashion.
May I see the document?
Yes, Your Honor.
May I respond, Your Honor?
Yes, ma'am.
A couple issues. One is the statute of limitations may be lapsed here in the state court, but there's a 10-year statute of limitations on bank fraud in federal court, and that would be clearly within that statute of limitations. The Attorney General's office cannot give immunity from a federal court prosecution, and regardless, rather the court acting as this witness's lawyer, she should have a lawyer appointed.
motion for the use immunity, and I am going to sign the order. And Ms. Watkins has been fully appraised.
She has, Your Honor.
Okay. And Ms. Watkins, do you have any questions about this?
No.
All right.
Your Honor, can the court inquire of the witness if she would like her own independent lawyer appointed?
Watkins, would you like your own independent lawyer appointed?
Yes.
Okay. First, we can give this to Mr. Patterson. And we have house counsel available.
Jackie George is in the back here.
All right, tell her to come into the courtroom, please. All right, we have our house counsel present. And for the record,
Morning, Your Honor. Jacqueline George, P26320, House Counsel.
all right, Ms. George, we are holding the preliminary exam, People versus Brian Banks. Ms. Watkins is a witness for the people. Defense attorney expressed some concern, even though I have signed that Ms. Watkins has been appraised of the use immunity. She indicated on the record she'd like her own independent counsel. So if you would like to take a minute and confer with her in the room before we proceed.
That'll
Okay.
be fine.
All right.
Okay.
She has a copy of the, she needs that.
Yes, Your Honor. You want to speak to me?
Yeah, I think both of you all need to go and have a discussion with the witness. Anything else you put on the record while we wait? Where's Mr. Hampton?
He's in the
He's gonna lock up?
Yes,
Who's gonna do him?
Miss
Oh,
Jackie George, when
okay.
she was in the process of talking.
Oh, she was talking to you. Well, here's the file. I see.
She's over the judge.
All right, Sandy, did you move your plants around? The bugs are flying today.
I didn't touch it. But, you know,
See the bugs? Yeah, since you left.
so what? You think I brought them?
Buggies.
I know. I'm so, I have to get that started.
While you're talking, let me get some water.
about like 47 maybe. And I just kind of stopped and just said, man, it's too much. I'm like, you know, too much. Well, I mean, that was, that one time I was up there around 250 or 260 with the bench press, but I never looked at that. Some of the, you know what, all that heavy weight, that's good for you anyway. Heavy weight is not good for you. You can do lightweight, high rep, and get the same thing. Well, no, you can still do some building with like super sets of call, like the light rep, lightweight, high rep, and then you'll like one after another, like so it still keeps negative listed, heavy weight, that's all the way I might get back to it, not to it. I was like the little pages and that stuff. All the big heavy stuff, we're not going to do that. Tearing a muscle again. Hey, did I tell you, I'm out over the weekend, we did this warrior ride, we went out there. Afghan guys that backed up, they're cheap, they're out there, going on like 90, there was a benefit ride for them, and we were out there, but her Delco was just some of the land over there, there was over 3 Skiway, another shot. Some of the sheriff reserves that were, I know a couple of them. This here, this is MIS right here. These are the guys that most of them are retired. Well, and I paid for it, but for $10 you can get 3 laps. But here's the deal, we got there at 4 o'clock. We were supposed to be on the track at 5. It was still 6 o'clock. I just laughed out of here. A couple of them, but hey, I got they were talking with the sounds. Yeah, they're over here. A couple of the guys went, but you didn't know what that's how you know, on the racetracks. This stuff's fun right here. Sometimes you got to wear a jacket. It's just a lot of night or day. But this guy's got a roll. That's the front end. I
See, 1 minute, sir.
Okay, if I could afford it, they let me be out there doing that, but I give that army out there, I'd be out there on the boat. They're living on that boat during the summer, because they both live like a half a mile from the Jefferson Beach. They go home, they do their little clothes or whatever, and they come back, they sleep on the boat. It's weird, it's really nice life. Well, she's trying. She was in the process of talking to him, and we called her out. So he's locked up. Yeah, but she was in the process. Well, I don't even think she had a chance to talk to him because I went back there and I told her that they need her to stand in on the witness. Yeah, you'll just go back. Yeah, that's all right. Are you ready now?
Yes, yes.
She's coming out. Just think. All right, I'm here. Okay, court's back in session. Remain seated and quiet, please.
Watkins, please be seated. And where's Ms. George? Oh. All right. Ms. George and...
Just 1 second, Judge.
Oh, I'm sorry.
That's all right. Just 1 second. Okay, thank you.
Okay, back on the record with People versus Brian Banks. And Mr. Patterson and Ms. George, you've had an opportunity to speak with the witness.
Yes, Your Honor.
Yes, Judge.
Okay. And what does she want to do?
She'd like to testify.
Okay. And you will be here
Yes, Judge.
representing her interests. Okay. Proceed.
And Judge, just for the record, can I just tender the order to Ms. Watkins so she can have it in her hand?
Yes, you may. And let me place on record now, Ms. Watkins, you've had an opportunity to speak with Ms. George, and you decided that you want to testify and answer the questions. Is that correct, ma'am?
That I will testify.
All right.
May I proceed, Your Honor?
Yes, you may. I'm going to ask the court reporter to read back the last question.
Yes. Question, well, actually, two questions, Judge, to make it have to make sense. Question, and what exactly did Mr. Banks want you to do with that particular program that you had? Answer, produce the paycheck stub and send it to him by email. Question, all right, now, did you produce a pay stub check for Mr. Banks? And then there was the objection by Mr. Gonick. And give me 1 second. Okay, thanks.
May I continue, Your Honor?
Proceed.
Yes, Your Honor. Ms. Watkins, so what we were talking about prior to the break, you had a program on, is this your home computer?
Yes.
And you had a program on your home computer, an Excel program that allows you to produce pay stubs, is that correct?
Yes. Yes.
Doing your line of business or doing whatever business you're conducting with IHI, did you have occasion to produce pay stubs for other businesses?
Yes.
Okay, so the pay stub program that you have on your computer is not in regards to your particular business, is that correct?
No.
It's in regards to producing pay stubs for other companies?
Yes.
Objection to the leading nature of the questions.
All right, tighten it up.
Yes, Your Honor.
Objection sustained.
Did Mr. Brian Banks come to you regarding your pay stub program that's on your home computer?
Yes.
And again, keep the microphone close
Yes.
so the judge can hear you. Tell the court exactly what he said as it relates to your pay stub program.
He wanted me to make a paycheck stub for him.
And did he tell you why he wanted you to make a paycheck stub?
Yes.
What did he say?
He was trying to get a loan for his thing.
For his what?
He was trying to get a loan.
I'm sorry,
He
you
was
said
trying to get a
something.
loan.
Did he
Okay.
say trying to get a loan for what? Did he say?
I don't recall really
Okay.
exactly at that time.
All right. And did you produce a pay stub for him?
Yes.
Now, did you actually make the pay stub and give him the pay stub, or did you give him access to your program? Or how did this happen?
I sent it to him by email
You sent what to him by email?
so he could look at the stub by email. So,
Well, what exactly did you send by email?
the file, I sent the paycheck stub file to him so that he could see if it met the need he needed.
All right.
I'm
and-
sorry, I'm missing the end of what you're saying. See if it
I
meant
sent
what?
the paycheck stub
Just the
file
end of what you said, to see if
to
it
see
meant the...
if it met what he wanted to.
Okay,
to
thank
be.
you.
And this file that you sent to Mr. Banks, was the information already compiled on the pay stub, or did he have to fill it in?
There's information in it that automatically populate.
And did you populate that for Mr. Banks, or did you send the file for him to do it?
I sent the file with it in there, and if there are any adjustments, he could make them.
Okay. Now, after you sent that particular file, did there come a time after that that Mr. Banks brought papers back to you?
He sent papers back. He sent the file back to print.
He sent the file back to you to print.
Yes,
And when you say sent it back, did he send it back by email?
email.
Okay. And when you received the file by email, what did you do with it?
Printed it.
And did you print it from your home?
Yes.
And the file that you printed, what exactly did you print?
A paycheck stub.
Okay. And was this a paycheck stub for Mr. Brian Banks?
Yes.
And did this paycheck stub indicate that he was paid by your business, IHI?
Yes.
And did the paycheck stub indicate a salary for Mr. Banks from IHI?
Yes.
And was that salary on there false?
Yes.
Was the pay stub that was sent back to you or that you gave Mr. Banks access to, was that pay stub false?
Yes.
Did IHI generate pay stubs for anyone?
Repeat the question.
Did IHI, your business, generate pay stubs for the business of IHI?
No.
Okay, so any pay stub that references IHI would be a false document.
Yes.
And I think you told the court that you printed out this pay stub, is that correct?
Yes.
And what did you do with that pay stub?
He He gave me a fax number to send it to.
All right, and did you fax the pay stub to the number he indicated?
Yes,
And when we say he, just so the record is clear, we're talking about Brian Banks, is that correct?
yes,
The individual that's here in court today.
yes,
And did you in fact fax the pay stub to some other location?
yes,
Do you know if you faxed it to a bank?
yes,
Do you recall the name of the bank?
no,
Do you recall how many pages you faxed with the pay stub?
no,
Was it more than one page?
not to recall.
Okay, so on the day that you're faxing it, you only send just the one pay stub, just one page?
Yes,
Mr. Gunn, you want to look at this?
Yes, please.
Yeah, can I first have the record just reflect that I've showed Mr. Gunn proposed exhibits number 1 and number 2. May I approach the witness?
Yesterday?
Ms. Watkins, let me show you what's been marked as proposed exhibit number 1. And just for the record, have I handed you a piece of paper?
yes,
And are you familiar with that piece of paper?
yes.
And can you tell the court how you're familiar with that piece of paper?
This is a document that I faxed.
And can you tell the court what that document is?
Copy of a paycheck stub.
And is that a copy of a paycheck stub that you sent to a bank on Mr. Banks' behalf?
Yes,
And is that an accurate copy of the paycheck stub that you sent to a bank?
yes.
And do you recall the date that you sent it to the bank?
It's dated June 29th. Yeah, June 29th.
June 29th. And let me ask you this. When you sent the check, did you send it by email or fax?
This is for a fax.
Okay. And when you send it by fax, did your business go at the top of the sheet indicating where it was faxed from?
Yes,
Okay. And does the paycheck stub that you have in your hand indicate that it was faxed from your business?
yes,
And does it indicate the date as well?
yes.
That being June 29th,
2010.
2010. And is that an accurate copy of the paycheck stub that you sent to a bank on that particular date, June 29th, 2010?
Yes,
People would move to admit proposed exhibit number 1.
Any objection? So admit it.
Now, again, referencing this particular exhibit that's now admitted, Ms. Watkins, is this paycheck stub for Mr. Brian Banks, is it false?
yes,
And you knew it was false when you faxed it, is that correct?
yes,
And Mr. Banks asked you to fax this pay stub, is that correct?
yes.
Did Mr. Banks offer or did he pay you any money for sending the paycheck stub?
Yes.
And how much did he offer you or how much did he end up paying you?
And nothing more than $100, I believe.
All right. And did you in fact get any cash from Mr. Banks for sending that paycheck stub?
Yes,
Let me show you what's been marked as proposed exhibit number 2. And for the record, have I handed you a piece of paper?
yes,
And are you familiar with that piece of paper?
yes.
And can you tell the court what it is I've handed to you?
A paycheck stub copy.
And is that a paycheck stub copy that you're familiar with?
Yes,
And is that something that you faxed from your place of business?
Yes.
And who did you fax that paycheck stub on behalf of?
Mr. Banks.
And is that paycheck stub false?
Yes.
Can you tell the court the date that you sent that paycheck stub?
July 1st, 2010.
The information that's contained on that paycheck stub as it relates to salary, is it false?
Yes.
As it relates to Mr. Banks being an employee of IHI, is that false?
Yes.
The paycheck stub indicates that Mr. Banks was a research attorney for IHI. Does it indicate on the stub that he's a research attorney?
No.
If you look at job title, I know the handwriting is small. Look at the job title.
Oh, yes, I see it.
And let me show you back to exhibit number 1. Does it indicate a job title for Mr. Banks for the first check that was sent June 29, 2010?
Yes.
And what job is Mr. Banks claiming to have had for IHI?
Research attorney.
And was that false?
Yes.
Did IHI in June 29th of 2010 have a need for a research attorney?
No.
Whose idea was it to put research attorney on the pay stub?
Mr. Banks.
After you faxed the second pay stub on July 1st, 2010, did you happen to receive a phone call from a bank?
Yes.
All right. Prior to that phone call, did you send a letter to a bank regarding Mr. Banks' employment?
Yes.
And was this a letter that indicated that IHI had a human resource person who was verifying that Mr. Banks had a job for IHI?
Yes.
And was that letter created by you?
Yes.
And was that letter false?
Yes.
Did Mr. Banks know the letter was false?
Objection
Yes.
calls for speculation.
Well, did you and Mr. Banks talk about the letter?
Yes.
And why did you send the letter to the bank?
They wanted additional verification.
And did you talk to the bank about additional verification, or did Mr. Brian Banks want you to send it?
Brian wanted me to send a letter.
And when you say Brian, we're talking about Brian Roderick Banks. Is
Yes.
that correct? So the letter was sent at the behest of Brian Roderick Banks. Is that
Yes.
correct? And the letter that we're talking about, was that letter false?
Yes.
On that letter, was it put on IHI Attorney and Consultants letterhead?
Yes.
Was IHI Attorneys and Consultants actual business?
No.
As it relates to the contact information for IHI Attorneys and Consultants, did you give your home address?
Yes.
Did you give a phone number for you to be contacted in the event someone wanted to speak to you?
Yes.
And did you send this letter off to the bank?
Yes.
After sending the letter, did you receive a phone call from someone from some bank?
Yes.
And what did you do as it relates to that phone call? Don't tell me what they asked you, but what did you do?
Verified the information on the letter.
You verified the information on the letter. Essentially, you verified Mr. Banks' employment with IHI Attorneys and Consultants. Is that correct?
Objection, leading and cumulative.
Objections overruled. Go ahead.
Yes.
Let me show you what's been marked as proposed exhibit number 3.
Just a moment. I'm sorry. Too much noise.
Let me show you what's been marked as proposed exhibit number 3. For the record, have I handed you a piece of paper?
Yes.
And are you familiar with that piece of paper?
Yes.
And can you tell the court what that piece of paper is?
A letter of verification of salary.
And is that a letter that
Deposit.
I'm sorry, what did you
It's a letter of verification to a bank.
to a particular bank.
Yes.
All right. Is that a letter you created?
Yes.
Is that a copy of the letter that you created? Is
Yes.
that a copy of the letter that you sent to the particular bank?
Yes.
And is that the letter that you've been referencing that is false?
Yes.
All right. Is there a signature line for a person to sign the letter as to who it's from?
Yes.
Is that your signature?
No.
The name on there is a Holly. What's the last name?
Reinberg.
And can you spell that for the court report?
REIMBERNT.
And do you know a Holly Reinberg?
No.
Has Holly Reinberg ever worked for your business, IHI Consultants, and or IHI Attorneys and Consultants?
No.
Is that the letter that you sent off to the bank? Is that correct?
Yes.
People would move to admit proposed exhibit number 3.
Any objection?
Nope.
So admit it.
Now, I can't remember if I asked for proposed exhibit number 2 to be admitted. If I haven't, I would ask that it be admitted as well.
Any objection?
Nope.
So admit it.
One second, Your Honor. I don't have any additional questions for this witness.
Cross.
Ms. Watkins, how did law enforcement contact you about this?
FBI agent.
Okay. Did they knock on your door?
They came to my house.
Okay. Did they call and make an appointment to see you?
No.
Okay. So I take it when they came to see you, the FBI agent showed you the badge, true?
I wasn't home.
Okay. They left a card?
Yes.
Did you call back the FBI agent?
Yes.
Okay. And was it a male or female?
Female.
And she indicated she wanted to talk to you?
Yes.
Do you recall her name?
Wynn Rosenthal.
Okay. And did Agent Rosenthal tell you you were in trouble?
No.
Okay. Well, you understand today that you have admitted to several different crimes, do you not?
Yes.
Okay. You committed wire fraud where you sent false information over the internet, correct?
Yes.
And you understand you can be prosecuted in federal court for that, correct?
No.
You don't understand that?
Can you rephrase that?
Sure. Did the prosecutor or did any agents tell you if you just come to court and testify that you won't be in any trouble?
Repeat the question.
Sure. Did anybody make any promises to you that you wouldn't be prosecuted in exchange for your testimony?
According to this document, yes.
Okay. And that's why you're testifying, correct?
Yes.
Okay. How long did the agent spend talking to you?
30 minutes?
Okay. And in addition to this, she asked you probably a lot of questions about Mr. Banks, did she not?
Yes.
Okay. And did it appear to you that she was fishing for information?
No objection. How would this witness know what the agent is thinking?
Did she, the agent, ask you a lot of different questions?
Yes.
Okay. Did it appear to you that the agent was fishing for information?
Objection. Relevant. Why is that relevant?
Mr. Gotti?
Just to show that, well, I'll move on. Okay, I'll move on. Have you ever been institutionalized for any type of psychiatric disorders?
Objection. Relevance.
Goes to her competency as a witness.
Competency today or back in June? He hasn't established a foundation for either today or back in June. He's just asking a broad question.
I'm laying a foundation to bring it up to today.
Well, I believe he has to ask the foundational question
Tighten up your
first.
question then, or lay a foundation, if you would.
Do you currently suffer from any psychiatric disorder?
No.
Okay. Have you ever been institutionalized within the past 5 years?
Repeat the question?
Have you ever been institutionalized in a mental hospital in the past 5 years?
No.
Okay. In the past 10 years?
Yes.
For what type of disorder?
Objection.
Objection sustained. We're really getting into private information. What is the relevancy, Mr. Gunnick?
Well, I mean, if it's a serious disorder, it still could be continuing today that may affect her testimony.
But you're asking her to reveal to this court on the record what triple won't allow us to reveal.
Well, I
So
think...
I need, if you're going to make an offer of proof that her mental state 10 years ago is somehow affecting her testimony today, I'll listen to that.
Well, it could affect her memory of over
that's
5 years ago.
speculation. Could affect her memory. We don't know what she's talking about. We have no idea what type of mental disorder, if any, that she had. I don't know.
Well, that's why the answer is relevant, I would submit.
I'm gonna sustain his objection.
This business that you had, did you have a number of customers?
Yes.
And did you have gross revenue every year?
Yes.
And did you file income tax returns in this business?
Yes.
Okay. And you listed all the expenditures you had for this business? Is that correct?
Yes.
Did the agent in this case ask you for a copy of your business returns to confirm that Mr. Banks was an employee or didn't receive some type of monies from your company?
No.
She didn't?
No.
Did anyone serve you with a search warrant or a subpoena requesting such records?
No.
Okay. How many times did you speak to the agent?
At least 3.
Okay. And when were those occasions?
Initially, early 2015, I believe.
Early 2015 was the first time?
I believe.
Okay. And then after that, when was that?
In 2015 as well.
Okay. And under what circumstances? Was it at your house or her office, or where was it?
Neither place.
I'm sorry, what?
Neither place.
Where did you speak to her at?
Outside of my place of employment.
Okay. And where's your place of employment?
Relevance.
That's not relevant. Not relevant.
Well, that's my point about a fair exam. I have no further questions.
I'm sorry, Mr. Connick, I didn't hear what you said.
I have no further
No,
questions.
before that, something about exam.
Yeah, I mean, that's my point about a fair exam. I
Okay,
have no
that's all
further
I heard.
questions.
Okay.
Redirect?
I have no redirect for this witness, Your Honor.
All right, thank you, Ms. Watkins. You may step down.
Your Honor, is this witness excused?
No, she should stay around, just in case you or Mr. Gunnick need to recall her.
Yes, Your Honor.
Okay?
Next witness, Your Honor.
Police requested. Call your next witness.
Yes, Your Honor.
Thank you, Ms. George.
And don't remember that for you. Oh, yes. And one for this.
Oh, yeah. What's up? Thank you, I appreciate it. You did the work you did great.
Thanks for moving that for me. Who's in? Oh,
Ms. Cooper, you know what you want to do with that?
May I have your name, please?
Pauline Forman,
Okay.
with an A.
Okay, your last name again?
F-O-R-E-M-A-N.
F-O-R-E-M-A-N. Thank you.
This one. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the whole truth, nothing but the truth, so help you God?
I do.
Okay, there's a microphone in the chair. I'll grab it and pick it up and talk directly into it. Thank you. You may be seated.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Could you state your name for the record, please?
Pauline Forman.
And Ms. Forman, are you currently retired?
Yes.
And how long have you been retired?
June 3rd, 2016.
And where did you retire from?
Diversified Members Credit Union.
And is that a credit union located here in the city of Detroit?
Yes, it is.
Do you know, or can you tell the court the address of that particular credit union?
1480 East Jefferson Avenue, Detroit 48207.
Okay. And has it always been known as Diversified Members Credit Union?
No.
What was the name prior to that name?
Detroit Metropolitan Credit Union.
How long did you work for Diversified Members Credit Union?
About 29.5 years.
And can you tell the court what was your role with Diversified Members Credit Union June 29, 2010?
Lending manager / loan officer.
And what does that mean to be a lending manager / loan officer?
Well, lending manager, you oversee all the loan officers, processors. You have a higher lending authority, but you have loan approval authority as well.
And you said / loan officer, so does that mean that you would review loans yourself sometimes?
Yes.
Okay. Did you have occasion on June 29, 2010 to review a loan request from a Brian Banks?
Yes.
And was this well, let me back up a little bit. The credit union, do they have members?
Yes.
Okay. And are members allowed to apply for a loan if they want a loan?
Yes.
Okay. Can a person who is not a member come into the credit union, at least back in June 29, 2010, can a non-member come in and apply for a loan?
They can apply, but before a loan is granted, they would have to be a member.
So in order for the loan to be granted, a person would have to become a member?
Yes.
So a non-member could walk in and say, I want a loan, and then you would say, well, become a member and we'll consider the loan.
Right.
Okay. When you are looking to become a member, can you become a member online, or would you have to come into the bank to become a member?
You have, if I'm not mistaken, at the time you cannot be a member online. You have to come in because there are documents we have to have verified.
All right. And during the course of time that you worked for Diversified Members Credit Union, did you have members who would apply all the time for loans?
Yes.
Would you also have non-members who would apply to be members of your credit union?
Yes.
When people would apply to be members, that paperwork was filled out. Would that paperwork be placed in your business's file cabinet for you to keep records of your members?
Yes.
And is that something that you typically do? You would keep the application to be a member within your business, is that correct?
Yes.
When a person who is a member wants to apply for a loan, that information, that application, would you also place that in a file and keep it as part of your business record?
Yes.
Did your bank put together a file for Mr. Brian Roderick Banks?
Yes.
Did you put together a file for application to be a member as well as a file for application for a loan?
Yes.
And are those documents documents that are still kept on file with the credit union?
Yes.
May I approach the witness, young? Mr. Forman, let me hand you what's been marked as proposed exhibit number 4. Just for the record, have I handed you a stapled pack of papers?
Yes.
And,
Yes.
And can you count and let the court know and the record know how many pages is in that proposed exhibit?
5.
And Ms. Forman, are you familiar with the 5 pages contained within proposed exhibit number 4?
Yes, I am.
And prior to me asking you any more questions, have you had occasion to look at those papers on prior occasions?
Yes.
And you had to review them, well, strike that. Have you been interviewed by the federal government as relates to the reason for you being here today?
Yes.
And during the course of your interviews, have you had occasion to review the documents that's contained within proposed exhibit number 4?
Yes.
You've already stated that you're familiar with the documents. Can you tell the court what it is that you have in your hand, that being proposed exhibit number 4?
These are the documents that's gathered at the time a membership, a person applies for membership of the credit union.
And the first page of proposed exhibit number 4, what is the first page?
It's the application and agreement to open an account.
And then can you go to the second page? What is the second page?
It's the back of the document where you sign and, fill in your beneficiaries or joint owners, things like that.
And can you go to the third page? What is the third page?
It's Mr. Banks' Michigan State University ID.
And does that Michigan State University ID have an actual picture on the ID?
Yes, it does.
And was that a picture that was submitted with the membership application?
I assume that it is. I didn't take in the application, but it's with the paperwork, so I assume that it is.
And is that a paperwork that's contained in the file for diversified membership credit union?
Yes.
Was that part of the file that is kept at the credit union?
Yes.
And are the IDs, are those items that are typically made part of the file when people apply to be members?
Yes.
Is there a second piece of identification that's attached with that proposed exhibit?
It's a Michigan State driver's license.
And is that a driver's license for Mr. Brian Roderick Banks?
Yes.
And is that driver's license, is that a copied photo of the license itself?
Yes.
Is it policy of the credit union to take a photocopy of the license and attach it to the application?
Yes.
Is it policy to maintain that identification, the photographs with the application itself?
Yes.
Is there another page after the driver's license?
There's the actual signature card.
And can you tell the court what is a signature card?
It's a card that you sign that stipulates that it's signed by you, and it's also shows who your beneficiaries and joint owners are.
Now, based on the policies and the documents that you have, would this have been an application that was filled out in person at the credit union?
Yes.
Objection calls for speculation.
Based on the policies of how they operate and do business. She can answer, I believe, as to what their policies, what they require their members to do. I believe she's already testified that to become a member, you had to come to the bank. You couldn't fill out that information online or somewhere else.
But she also indicated that she wasn't the one that took this application.
But she's indicating that it's the policy. The court can accept what's the policy of the bank as to what is the normal procedure for her as well as the loan officers under her.
Objection overruled. Go ahead.
It is the policy of the credit union to do these documents in person.
And are you aware of any reason why anyone in your bank would have deviated from the policy?
No.
Ms. Forman, the documents that you have in your hand, proposed exhibit number 4, are those accurate copies of the documents that's contained within the file currently maintained at Diversified Membership Credit Union?
Yes.
People would move to admit proposed exhibit number 4.
You got it?
Okay.
All right. So admitted?
Thank you. Ms. Forman, does the application indicate a date as to when the person who applied, that being on the paper Brian Banks, applied for membership?
Yes.
And the date that Mr. Banks applied for membership?
6/29/2010.
And 6/29/2010, would that be the date that Brian Banks entered the location and applied for membership at your credit union?
Yes, that's the day he signed the papers, yes.
Now approach the witness. Ms. Forman, let me hand to you what's been marked as proposed exhibit number 5. Have I handed you what appears to be a 2-page document?
Yes.
And are you familiar with that document?
Yes.
And can you tell the court how you're familiar with that document?
It's the application for credit or loan.
And is it a copy of an application for credit or loan that your bank received by someone requesting a loan?
Yes.
And is it a loan application or loan request from Mr. Brian Banks?
Yes.
And is that a copy of the application that you currently maintain within your credit union?
Yes.
People would move to admit proposed exhibit number 5.
No objection.
So admitted?
Ms. Forman, was that loan application, was it delivered in person or was it faxed?
It was faxed.
And can you tell the court where it was faxed from?
IHI Attorneys and Consultants.
And does it give the date as to when it was faxed?
June 29th, 2010.
And does the application, does it give, what type of information does the application give?
It gives you your personal information, name, social security number. It also gives your employment and income, where you work. And it gives it asks for your personal references, also your mortgage, your vehicles, other creditors that you may have, and whether you file bankruptcy or not, and also do you want credit, life, credit, disability insurance on the loan, and then it has a place for your signature.
All right. Now, you mentioned that this particular application for a loan was faxed. Are you allowed, once you are a member, are you allowed to apply online or apply by fax for a loan?
Yes, you can.
And in this particular case, you received the loan application from IHI Consultants. Is that correct?
Yes.
You mentioned that on the application it states something about employment. Does the application state Mr. Banks' employment?
Yes.
And what is on the application?
IHI attorneys and consultant.
And that's listed as his occupation?
It shows that's where he works, and then his title was research attorney.
Okay. And as a loan officer, are you relying on that particular statement as relates to your determination whether to approve a loan or not approve a loan?
Partly. Yes.
Are you also looking at level of income?
Yes.
And does it reflect on the application Mr. Banks' level of income?
Yes, the annual salary.
And can you tell the court what Mr. Banks said his annual salary was?
From his job was $92,400.
And that's what's on that application?
And there's some other income as well.
Okay. And do you rely on the salary information also as a factor to determine whether you will give a loan or not?
Yes.
When you were going over the decision to whether to approve a loan or not, did you have occasion to call someone associated with IHI Consultants to verify employment?
Yes.
And do you know who you called?
There was a letter in the file, and it was the lady's name is on the letter.
Let me show you what's been marked as People's Exhibit number 3. Are you familiar with that document?
Yes.
And can you tell the court what that document is?
It was a letter from IHI attorneys and consultants signed by Holly Remberg stating that Mr. Banks had requested direct deposit from his job to be deposited at Detroit Metropolitan Credit Union.
All right. And when you read that letter, did you have occasion to call that number?
Yes, I did.
And did you speak to a person?
Yes, I did.
The person you spoke to, was it a man or woman?
Female.
Female. And based on that conversation, were you at least on his face at that time satisfied that Brian Banks was employed and was looking to have direct deposit into your bank?
Yes.
And that particular job verification, is that a factor that you also looked at and weighed as relates to your decision whether to approve the loan?
Yes.
Along with the application, did you receive any pay stubs?
When he first submitted the loan, there were one pay stub. We had to call to get a second one.
All right, and you say the loan application, when he submitted the loan application, there was one pay stub. Is
Yes.
that correct?
Mm-hmm.
Let me approach and show you what's been marked as People's Exhibit number 1. Are you familiar with that document?
Yes, I am.
And can you tell the court what that document is?
It's a copy of his pay stub.
And is that the pay stub you received with the application for the loan for Brian Banks?
Yes, it was faxed June 29, 2010.
And was it faxed? Who was it faxed from?
IHI attorneys and consultants.
And is that a pay stub that you relied upon as it relates to helping you make a decision whether to approve the loan?
Yes.
You stated that there was just one pay stub submitted with the initial application. Is that correct?
That's correct.
Did you ask for a second pay stub?
Yes.
And can you tell the court why you're asking for a second pay stub?
Well, it's our policy that we get 2 pay stubs with each loan application.
And did you tell either Mr. Banks or someone else that you needed a second pay stub?
Yes.
And do you recall which, did you tell that to Brian Banks or who you believe to be Brian Banks?
Yes.
All right. And let me show you what's been marked as Exhibit number 2. Are you familiar with that document?
Yes.
And can you tell the court what's that document?
It's an additional pay stub faxed in on July 1st, 2010.
And is that the second pay stub you were looking as relates to helping you determine whether to give the loan or not give the loan?
Yes, it is.
After you accumulated all the paperwork as relates to the loan, did you then forward the information, the application, the letter, the pay stubs to anyone else within your credit union?
Well, actually, I initially denied the loan, but I decided to consult with the CEO of the credit union, so I took the loan application and the paperwork to her to see what her opinion would be.
Okay. Forman, let me show you what's been marked as proposed exhibit number 6. Are you familiar with that document?
Yes, I am.
Have I handed you, it's a piece of paper, is that correct?
Yes.
And you've already stated that you're familiar with it. Can you tell the court what it is?
It's actually an internal document where we put the member's name, their account number, the amount that they request, and for what purpose. It also has their annual income, their monthly income, and it has the credit score. It also contains a debt-to-income ratio and also the unsecured debt-to-income ratio. And then it has a spot where it shows the action taken by the loan officer, where the loan is approved or denied, and for how much it's approved for, the type of loan it is, and if they want credit life, credit disability insurance. And it also contains the comments made by the loan officer.
All right. And is that an accurate copy of the internal document that is currently maintained in the file for Mr. Brian Banks?
Yes, it is.
People would move to admit proposed exhibit number 6.
No objection.
So admitted.
Ms. Forman, initially when the loan was applied for by Brian Banks, how much was being requested?
$7,500.
And you stated that initially you denied the loan, is that correct?
That's correct.
And then you wanted a second opinion, is that correct?
That's correct.
And who did you go to?
Kathy Trimbath.
And can you spell the last name?
Trembath.
And is that Kathy with a K or a C?
K.
And you wanted the CEO opinion as relates to the loan, is that correct?
Yes.
Was the loan eventually approved?
Objection. That would be hearsay.
I think she can testify as to whether it was approved, whether the loan is approved.
Objection is overruled. Go ahead.
The loan was approved for $3,000.
Okay. And the $3,000 is actually an amount that's written on that admitted exhibit number 6, is that correct?
That's correct.
Once the loan is approved, is Mr. Banks given the opportunity to come and pick up his money?
Yes, normally we would call him, let him know how much his loan is approved for, and find out what time he would like to come in. And that's also on this document, the pickup time.
And the pickup time on admitted exhibit number 6 was what?
Pickup date 7/1/2010, pickup time 3 p.m.
Let me approach and show you what's been marked as proposed exhibit number 7. Are you familiar with that document?
Yes, I am.
Is it a one-page piece of paper?
Yes.
And can you tell the court how it is that you're familiar with that piece of paper?
This is the Detroit Metropolitan Credit Union's promissory note and security agreement.
And based on, well, is that an accurate copy of the promissory note that's contained within the file for a diversified membership credit union?
Yes, it is.
People would move to admit proposed exhibit number 7.
No objection.
So admitted.
Ms. Forman, are you able to tell from that admitted exhibit whether Mr. Banks appeared in person or how he was able to get his, not get his check, how he was able to sign the promissory note?
Yes, he came in person.
And how is it that you know he appeared in person?
Because our procedure is when a person comes in to get the loan proceeds, it was done in person unless, the documents were faxed or sent back with notary signature and all of that. But showing here at the bottom, when a person comes in, we write their identification, their driver's license number under where they sign, and we also put the year of expiration for that ID as well.
And is all that contained on admitted exhibit number 7?
Yes, and it's signed by the witness as well.
And the witness being some employee at your credit union?
Yes.
And it's signed by Mr. Brian Banks?
Yes, it is.
And can you tell the court the date that he's signing for the loan amount that was granted to him?
July 1st, 2010.
Now, Ms. Forman, let me ask you this. If you were aware that the pay stubs were false or fictitious, would you have granted the loan?
No.
Objection. As soon as a fact, not an evidence. This witness testified she denied the loan.
I'm not sure I'm understanding your objection, Mr. Gunn.
This witness never testified she approved the loan. Her only testimony has been that she denied the loan.
That's true. The question is, if she had known that the documents were false, would she have approved the loan? Is that the question?
That's the question.
No, the objection is overruled.
You had known that the pay stubs were false, but you have approved the loan.
No, I would not have.
Did you rely on the pay stubs in helping you make your decision?
Yes.
If you had known that the human resources person or IHI Consultants was a fictitious name, would that have been a factor in determining whether to approve the loan?
Yes.
If it had been made aware to you that there was no actual employment with IHI Attorneys and Consultants, would that have been a factor in whether you approved the loan?
Yes.
Did you rely on the assertion that Brian Banks was employed with IHI Attorneys and Consultants in helping to determine whether the loan is approved or not?
Yes.
Whether the loan is approved or not?
Yes.
After the loan was approved, was the loan paid off?
Eventually.
And when you say eventually, did your credit union have to hire attorneys and pursue it in court?
Yes.
And did you have to, or did you reach a settlement? Did your bank reach a settlement with Mr. Brian Banks?
Objection. One, lack of foundation and lack of personal knowledge.
Objection sustained.
Ms. Forman, involved with the settlement process?
No.
Okay. The loan was being paid timely.
I'm sorry, ask me that again?
Did you become aware, or was it made part of your job? Well, let me ask you this. If a person does not pay, if a member is not paying their loan, what would typically?
It would be turned over to the collection department.
Okay, and prior to being turned over to the collection department, the person who approved the loan,
Would that person be what?
called.
Yes. If normally, if the person misses the first payment or the second payment, then you can receive a call saying what is happening with this loan. It's brand new, payments are being missed already. Normally the collection person would call, the loan is not being paid, or is it the member's fault that the loan is not being paid? So she'll call to investigate, and then In this particular case, she called me and said,
Objection here, sir.
Objection sustained.
Yes.
well, in this particular case, I had to call Mr.
So, let me ask you this. Did you receive a call regarding Mr. Banks after the loan was processed and given to him? Proceed to call Mr. Banks regarding the loan.
Yes.
I don't have any additional questions for this witness.
Good morning, ma'am.
Good morning.
If I understand you correctly, you didn't approve this loan, did you?
Yes, I did.
You did? I thought you said you denied the loan.
She told me to give him $3,000, and at that point, I approved the $3,000.
Okay, but your manager approved the loan, correct? During examination continuing, I believe that the court did violate the court rules by not allowing me to go before the chief judge. I believe that we set forth a sufficient basis to have this court disqualified, and the mere fact that the court wouldn't follow the court rules and allow us to go before the chief judge is further evidence of this court's bias against Mr. Banks. If I have to argue this, what I am stating is this, is that as it relates to the 3 felonies, there is one common denominator element in this case that they have failed to show, and that's an intent to defraud. Mr. Banks, while there may have been misinformation on the loan applications, that he is not charged with the offense of giving misinformation on a loan application for at least 3 of the felony offenses. There has to be an intent to injure or defraud. In this case, this court precluded me from getting into evidence to show that not only was the loan amount repaid, but substantially more than the loan amount was repaid prior to any criminal investigation in this matter, which would negate any type of criminal intent in the matter for the 3 felonies that are charged. In addition to that, Your Honor, the uttering and publishing charges must fail because the documents in question were never shown to be financial instruments. Just because a document contains misinformation and is presented to someone doesn't make it a financial instrument. There's been no evidence to that effect. This is not like a bogus check, which this court sees a lot in an uttering and publishing case, or even a gift certificate. So for those reasons, the uttering and publishing counts must fail. In terms of the misdemeanor, it's a tag-along charge, which just is...
The false pretenses are a felony, then there's another misdemeanor of false statements. That's the misdemeanor.
That's the misdemeanor, false statement. In terms of the false pretenses also, there was no concrete testimony from the bank that they suffered any type of injury. I mean, the fact that monies were given, there was testimony that monies were repaid. We never heard the specific amount that was repaid. So without that element being made, that charge must be dismissed as well.
Yes, in rebuttal. All of the points that Mr. Gonick raises are points, that's a defense. That's a defense that he can raise. That's a question of fact. It doesn't go to the heart of the particular case. There's nothing in the jury instructions for either uttering and publishing or false pretenses that says that the defendant is not guilty unless, or he's not guilty unless, or he can show that he repaid it at some point in time in the future. The crime was committed when he submitted the application. When he submitted the application is when the crime was committed for both uttering and publishing and false pretenses. And the instructions do not say anything about some type of judgment. The bank suffered a loss. The bank had to resort to getting attorneys and reaching a settlement. They had to reach a settlement just to get, and the settlement indicates that to get some of their money back. Not all of it. Now, I don't know how much Mr. Banks paid, but the bank reached a settlement to finally obtain judgment as it relates to this particular situation. But again, the settlement and what happened after the fact is not relevant as it relates to the crime that was committed, which that crime was committed on June 29, 2010. People would ask that the court bind them over on all charges.
And Mr. Gonick, is there any last thing you want to say, sir?
Well, I would just point out once again, there has to be the intent to defraud. There was no evidence. The fact that there was a settlement doesn't mean that it was less than the amount that was given, and that's why I believed it was relevant to show that far more was paid back before any type of criminal investigation was launched.
And the prosecutor gets the second to last word. Anything else you want to say?
No, Your Honor.
Okay. All right. Basically, the court is going to adopt the argument of the prosecutor in binding Mr. Banks over on all three charges. I believe that, as the prosecutor indicated, this crime was committed when Mr. Banks conspired actually with Ms. Watkins to defraud the bank by submitting false documents which the bank officers and CEO relied upon to issue him a $3,000 loan. That really is the end of the matter. The fact that he paid the loan back, that he paid the loan back maybe with interest, really is is not important to this case. That may be important in the civil case, is not important here. Mr. Banks is bound over. The misdemeanor will tag along. And because he's out on bond, his AOI date, let me ask the prosecutor, any objection to his bond continuing?
No, Your Honor.
All right, the bond is continued. His AOI date, August 23rd, 8:30 a.m.
Thank you, Your Honor.
Mr. Patterson, who gets the immunity paperwork? Does that remain